So for Muslim law, from Unit 5, there is another concept which we have that we will be discussing. Okay, it is basically a legislation that we have, Family Courts Act 1984. Okay, so with regard to that, it's a very small legislation anyways, but with regard to that, we have like its constitution, powers, functions, and all that stuff, like what kind of matters it will decide, its jurisdiction, and how family courts would be set up, right? Those provisions are being given here.
Okay.
So regarding Family Courts Act 1984, the legislation is having basically 6 different chapters, like a preliminary part which tells us about name of the legislation, its applicability, wherein all it's applicable, plus few definitions we have. Then we have a provision regarding family courts, which mentions how a family court will be set up, and other stuff. We have the jurisdiction in third chapter, which tells us wherein all family courts will be having jurisdiction. What kind of court will it be? Is it a civil court? Is it a criminal court? What kind of court it is? Then in the fourth chapter, it tells us procedure, how matters will be decided in family court. Then in chapter 5, appeals or revisions. Is it allowed or not? And last, we have like a miscellaneous part. So there are basically 6 different parts, and in total, we have like 23 different chapters. Okay, so what are the main objectives of this Family Courts Act? Right, Family Courts Act 1984. First of all, to provide for establishment of family courts, because this regular civil courts, these were having like jurisdiction to try the matters which were falling under family court, right? Which are now falling under family court. This regular civil courts were only deciding. And just because there were already so many cases pending, it was taking long time to decide the matters. So this act basically aimed that it will provide for establishment of family courts in places, right? Wherever might be it's needed, or based on population, they will decide where a family court is to be set up, and accordingly its process for establishment is also being mentioned under this legislation, right? So that is the first thing, establishment of family courts. Secondly, to promote conciliation and mediation in disputes relating to marriage. Now, family courts are being set up whenever any sort of matrimonial dispute comes before these courts. They should try to promote conciliation and mediation, right? They should try to bring some settlement between the parties. There is some time period also given, like if someone files a case, okay, like in Hindu law, if someone files a case for divorce, right, there will be a certain time frame given for the parties to think about it and then take a decision. Then all this conciliation mediation process also happens, wherein both the parties are given some time, and also some, like this family courts would take up some initiatives in order to see if conciliation or mediation is possible between them or not. So that is also another thing which this Family Courts Act tries to promote. And lastly, secure speedy settlement of disputes relating to marriage. So marriage, as in there are a lot of things related to marriage. So all those things which are falling under jurisdiction of Family Courts Act, so that these matters are being decided faster, right? Because they are not having burden of any other matters, but it's only matrimonial disputes. So it was expected that there will be speedy settlement of disputes which are coming before them. So these are basically the 3 objectives for which with these objectives only Family Courts Act 1984 was being established. With regard to scope or applicability of this legislation, as of now, it is applicable to the whole of India, but it was previously not applicable to Jammu and Kashmir. Now, under this Jammu and Kashmir Reorganization Act, it's applied to the union, both the union territories, Jammu and Kashmir as well as Ladakh. So this application part is given under this preliminary thing only, and these objectives are being mentioned in preamble. Okay, so these are the 3 objectives. Then we have application of this legislation. Now, establishment of family courts. So wherein all will we have family courts and how they will be established? With regard to that, provisions are given in this second chapter and section 3 of the Family Courts Act. So it makes provision relating to establishment of family courts, and this power is being given to state government. So state government is having the responsibility of establishing family courts by notification after consultation with High Court. So state government to take a decision with regard to it, and they will also consult High Courts with regard to this, because we have seen, right? For subordinate courts, High Court is like the main body which would be supervising and also ensuring whatever is needed is being done. So that is the reason why here also consultation with High Court will be done, and after that state government would decide whether like a family court is needed in a certain place or not, and accordingly it will be established by way of notification. Section 3 of Family Courts Act provides that these courts are to be established in the town, on the city where the population exceeds 1 million, or in any area where state government considers establishing it. So first of all, this is still needed. If in any town the population exceeds 1 million, then in that particular town family court has to be established. But apart from this also, even if population is less in some places and state government still feels that we need a family court, then also that discretion is being given to state government with regard to like the minimum number. If they want, they can establish as well. So this is regarding the establishment. State government is being given the power. They will do it by way of notification after consultation with High Court. So with regard to population, if population exceeds 1 million, it is needed in a certain town, and also state government is given discretion that if they consider, they can also establish it in some other places as well. Similarly, state government shall, after consultation with the High Court, specify by notification the local limits of the area to which the jurisdiction of family court shall extend, and may at any time increase, reduce, or alter such limitation. So with regard to their jurisdiction in what all matters, family court will take a decision that is already given under the legislation. But with regard to its territorial jurisdiction, again, state government would itself specify that in this area, this specific court will be having jurisdiction to try the matter. There may be a time when like there are like 2 family courts being established in like one town, right? If it is like a very big town, 2 family courts are being established. In such a case, government may also reduce power of this previous court, right? If they feel like, or they may extend its power also. They may make changes in its powers also. So once some power is being given, territorial power, right? Territorial jurisdiction, that may be subject to change also based on the need or requirement. So they will also specify local limits of the area within which that family court will be having jurisdiction. So at any time it may increase, reduce, or make changes in terms of the jurisdiction which is being given to a certain court as well. Family courts are designed to deal with disputes arising in family matters such as divorce, child custody, etc. We do have like a long list of matters which will fall under the jurisdiction, right? Jurisdiction of family courts as well. And the first family court was established in Rajasthan in 1985, just a year later of having this legislation. Okay, so this is with regard to establishment of family court, that state government is given this power. If population is more than 1 million, it's necessary. Otherwise also state government is having the discretion or the freedom to decide if family court is needed or not. So regarding its jurisdiction, its subject matter was whatever is its jurisdiction that is already being specified under the legislation. With regard to those matters, these courts would take a decision. But if it is needed that they need to specify jurisdiction with regard to like the area where it is applicable, that will again be mentioned in the same notification. Government will take a decision regarding it, and such jurisdiction is subject to increase, reduce, or changes as well. Okay, so regarding establishment, there is one topic, so you can read this part. It is given under section 3 of the legislation. Okay, this is like the summary from that specific section. Then we have this duties of family courts. So family courts, they should assist and they should try for settlement. Whenever parties are coming before them for any sort of matrimonial disputes, they should not like instantly give a decision or try to, like provide whatever relief they are seeking, but rather they should try to give, like reach a stage of settlement, like conciliation and stuff, that should be given more priority. That is like a duty that these family courts are having, that they should try to settle the matter between parties. Then personal appearance is mandatory. Parties need to go to the court. It's not like only the lawyers would go and they would represent them. That would not happen. They need to appear themselves and put forward their matter. They need to let the court know what is the matter and everything. And accordingly, it will be like decision will be taken with regard to these matters. Then we have provisions regarding jurisdiction of family courts also. We know how family courts will be established, where and all it will be established, who will establish it. But for what all matters, family courts will be having jurisdiction. Right? That is jurisdiction of family courts. So it is again given under chapter 3 and section 7 of the Family Courts Act, the third chapter, which is specifically on jurisdiction, that mentions with regard to jurisdiction of family courts. So regarding jurisdiction of family courts, it is being mentioned under chapter 3 and section 7 of the legislation, which tells that in matrimonial matters also what sort of matters will go before these family courts. And 8.1 is exclusion of jurisdiction. Okay, so 8 is exclusion of jurisdiction. Section 7 is also important, which is jurisdiction of family court. So family court shall have and exercise all jurisdiction exercised by any district court or any subordinate court under any law for the time being in force in respect of suits and proceedings coming under jurisdiction of family courts. Otherwise, what happened is these matrimonial matters were decided by the regular civil courts only, right? So whatever powers those courts were having, whatever jurisdiction they were having, the same jurisdiction will apply with regard to these family courts also. So same powers they will also enjoy, but these are limited to only matrimonial disputes, which are mentioned under section 7 of the legislation. So with respect to all those matters, family courts will be having the power or the authority to take a decision. So what are these jurisdictions? Basically, there are these 5, 6, 7, 8 different jurisdictions that we are having. First one is a suit or proceeding between parties to a marriage for decree of nullity of marriage. So sometimes what happens is, like, under some misunderstanding or misconception, right, there may be like a person who enters into, like 2 marriages. Okay, so in Hindu law, suppose it's only like 1 marriage is allowed, but something happens, or that might be one of the parties was not aware that this other party is married or something. They just get married, and after that what happens is this previous wife may come and say that no, I'm already married to him, so your marriage is like invalid, right? Because second marriage will be invalid, first one will be valid. So in such a case, right, it might be needed that court passes a decree for nullity of marriage. That means court will declare that this specific marriage is null and void, and this marriage is not binding. Why? Because there was already an existing forced marriage between the parties, right? So we need to declare that this marriage is null and void. For that also parties may go before court. Okay, so that is the first jurisdiction which we have, to declare a marriage null and void. Or it might be restitution of conjugal rights, judicial separation, or dissolution of marriage. So restitution of conjugal rights, have you got this somewhere?
No, madam.
So restitution of conjugal rights, right? Basically, it is like we say, right, in India that you don't marry the person, you marry the family, right? Why we say it? Because there are some responsibilities or obligations that also come along with the marriage, right? So there are some expectations that parties will be having, right, from one another. So if someone, right, without any valid justification, simply just, like ignores all those responsibilities and all that stuff, right? Basically, like as if there is no connection sort of a thing, right? In such a case will be filed before court saying that court should pass an order for restitution of conjugal rights. That means conjugal rights as in being married to someone, whatever rights you are having, right? That you may ask the other person to, like get involved in some family function or some family matters and stuff, right? For those, court will ask the party, right? Court will say that you don't have any valid justification for ignoring this person's family altogether, so you should not be doing it, but rather you should be taking part in it and stuff. Okay, so that is nothing but restitution of conjugal rights, which is also very common, right? There might be cases where, like two persons got married, but then one of them said that for my work, I need to live in this other city. And then after that, like no connection with the family, no, nothing about it, right? In such cases, a case may be filed for restitution of conjugal rights, that because you are married, you have some obligations, or I have some rights to expect something from you. Okay, so that is nothing but restitution of conjugal rights, which is like a very popular or a very common thing. Okay, for that also, parties will go to family courts only to ask for this restitution. Okay, then we have judicial separation, dissolution of marriage. So what is the difference between judicial separation and dissolution of marriage?
Judicial separation means probably by an non-compliance of law, probably. Then dissolution of marriage means both the couples at their own will taking a divorce kind of thing.
So dissolution of marriage basically means divorce only, but judicial separation might be like, say in case of divorce, what happens is parties have finally decided, right, that okay, fine, we are ending this marriage. But there may be a time where parties are, like yet in that stage of deciding or something, or maybe if they have filed a case before court, court also would give them some time to think about it, right? Decide on the matter. So in such cases, there may be judicial separation, that court will ask the parties that, okay, fine, you are judicially separated. You are no more bound to stay together in one house and stuff. But during that stage, right, if parties feel that, no, fine, we can settle the matter between us and stuff, they can get it done. That means their marriage is not yet, like their marriage has not ended yet. They are just judicially staying separately. Okay, but with regard to dissolution of marriage, it is like completely ending of the marriage. It is like divorce, right? So that is the basic difference which we have. So in all these matters, family courts will be having jurisdiction if someone wants a marriage to be declared as null and void, for restitution of conjugal rights, for judicial separation, for dissolution of marriage. All right, all these are matrimonial suits for which parties will approach family court. Then we have another one, a suit or proceeding for a declaration as to validity of a marriage, or as to matrimonial status of any person. So why do we need a declaration with regard to validity of a marriage, right? Sometimes what may happen is, take for example, two persons got married in the temple might be. Okay, so with their family members were not involved and family members are not, like accepting that marriage. In such a case, what will happen is both these parties are already married, right? They have performed the rituals and stuff. In such a case, what will happen is, for them to be accepted by the society or family, they may approach the court. That court will declare that whatever marriage they have performed, that marriage is valid and binding for the parties. Right here, what happened is, court declared that this specific marriage is null and void, which mostly happens in case of like a second marriage, where one of the parties did not know that other person is married and stuff, right? And accordingly got married. So it would be like null and void. But in the second one, declaration as to validity of the marriage, that parties will approach the court and court will say that yes, in this specific marriage, they have performed what are, like the rituals and stuff. So this marriage is valid, this marriage is binding. Accordingly, families will have to also accept that yes, this marriage is valid and binding. Or as to the matrimonial status of any person, or someone may not accept that yes, this person is husband or wife of this other one, right? In such cases also, parties may approach the court for matrimonial status of any person, right? That court will recognize that yes, you are husband or wife of so and so person based on this specific marriage, because this marriage is binding. So that also may be one of the matters that may be decided by family court. A suit or proceeding between parties to the marriage with respect to property of the parties or of either of them. So after they got divorced and stuff, whatever properties, it may be like a joint property that both the persons had purchased, how to decide on that matter. Or it might be that one person is not financially independent, so this other person need to, whether this person will get some property or some other stuff or not, those matters might be decided. So with regard to property which is involved in a marriage or between the parties, right, whatever properties they hold, with regard to that also, decision they may not be able to come to a conclusion, and they are accordingly approaching the court to settle the matter with regard to it. So this is property of the parties, both of them or either of them, they need to decide. A suit or proceeding for an order or injunction in circumstances arising out of marital relationship. So there might be some order or injunction also, which parties may want to get from court. Okay, take for example, someone, like after divorce, right, they fought for custody of the child. Okay, and one of the parties got custody of the child. All right, take for example, might be wife got custody of the child. It was like a small kid. Wife got custody of the child. Now wife is saying that I got custody and also I want to keep my child away from her father. All right, so what happens is, this father might be, he would get drunk and he would come and meet his daughter and stuff. So in such cases, what wife will do is, she will file a case to get an order from court, or an injunction order she would try to get, that this husband should not be meeting his daughter, right? He is not having that right. Or he should not be meeting her too often, only might be like once a year or something, that thing it will be given, right? So those sort of injunctions also might be passed, that suit or proceeding for an injunction order for any sort of situation that might be arising out of marital relationship. So for that also, parties may be approaching the court, and in that case, again, family courts would be having jurisdiction to try the matter. Suit or proceeding for a declaration as to legitimacy of any person. So whether a child is legitimate or not, with regard to that, there might be like a question. Regarding that also, parties may approach the court and get an order from the court with regard to it, whether child is legitimate or not, and whether child will be having right over property of parents or not, right? Those matters also may be decided by a family court. Suit or proceeding for maintenance or alimony. After divorce, who will be getting maintenance? How much of maintenance parties will be getting? All that stuff also will be decided by the court with regard to it, right? So it is usually done based on the personal laws of the parties, right? How much amount they will be paid and other stuff. Then a suit or proceeding in relation to guardianship of the person or custody of or access to any minor, right? Who will be having custody of the child plus access to the minor, right? If like husband got custody of the child, whether wife will be having access to the child or not. If wife got the child, whether husband will be having access to the child or not, right? That access also is very, like a very common thing, right? The other party might say that this person is not, like it's not good that this person meets the child, might be because this person is insane, might be he would get drunk, or because of some other reasons, right? So for those matters also, case may be filed before court. And last one, right, for all these things, right? So divorce, declaration of a marriage as null and void, judicial separation, validity of marriage, then property, settlement of property of parties, injunction order regarding marital relation, declaration as to legitimacy, maintenance, guardianship, all these matters, right? These are what? These are civil suits, right? Only parties are involved, and accordingly, they would ask for an order from court, right? So when a court is deciding a matter coming under all these things, right? 5, 6, 7, all these 7 points, it will be considered that family court is what? It's just like a civil court that we have, right? Because it is trying to replace the civil court in terms of marital disputes, right? So when a court, family court, is deciding all these matters, we would say that this court is like similar to a civil court. Okay, but there is one matter wherein family courts will have this, like the jurisdiction just like a magistrate court. Why is it so? Because there is one provision, okay, this code of criminal procedure we have, right? The process how criminal law will be applicable. There we have one section, section 125, which talks about maintenance of wife, children, and parents. Okay, so maintenance need to be given to wife, children, plus parents. Like children also need to give maintenance to their elderly parents who are not having sufficient resources to maintain themselves. Similarly, parents are also liable to give maintenance to their minor son or unmarried daughters. Okay, so all these things are mentioned under section 125 of CRPC. Now, this law is applicable irrespective of, like the religion of the person, right? This is like a general law that we have, not like a personal law. And it is coming from this criminal procedure, right? So if a family court is deciding a matter with regard to maintenance amount to be paid to any of these, that time also we will consider that this family court is what? It is a court similar to magistrate of first class. Why? Because it is deciding a matter which otherwise falls under magistrate court. Okay, so for all these remaining ones, we will consider it's a civil court. Only for this matter, when it's deciding a maintenance suit under section 125 of CRPC, we will consider that it is like a criminal court. Okay, so this is with regard to jurisdiction of family courts. Is that part clear?
Yes, madam. Madam, this Family Court Act is applicable equally for Muslims and Hindu both, right?
It is just a code that is being set up. Otherwise, matters will be decided based on personal laws only. So for any relation, if the matter is falling under any of these things, right, then they can approach the family court. It's just a code, but otherwise matters will be decided based on their personal laws only inside the court.
Okay.
Then we also have this provision with regard to Uniform Civil Code. So Uniform Civil Code or UCC, it is provisions are being given under Article 44 of Constitution. So Article 44 is coming from Part 4 of Constitution, right? So we have like two different parts, Part 3 and Part 4. Part 3 is fundamental rights, which are binding on the state, right? They need to provide it, it is guaranteed to us. But with regard to this Part 4, right, these are not guaranteed to us, but these are only some guidelines or directions given to the state that whenever you are introducing a legislation, whenever you are introducing a scheme, you need to keep these principles in mind, and accordingly you need to try to introduce the legislation or scheme, right? So because these things are not binding, because it involves lot of resources and stuff, this discretion is given to the government, and whenever you can, you try to implement these principles. All right, so UCC is also falling under that directive principles only, which is not binding. We cannot go to court, file a case for Uniform Civil Code, right, for bringing of Uniform Civil Code, but it is something that government would try to introduce based on availability of resources and other stuff, right? So it's been so many years, but still there is no, like proper step being taken with regard to introduction of Uniform Civil Code. But if you look at this 2019 Lok Sabha election manifesto, I have added this link also. There they have mentioned, right, BJP has mentioned or promised that they will be implementing Uniform Civil Code if they come to power, and accordingly they will like take actions with regard to it, right? So might be we can see some legislations coming in and stuff, but yeah, this is the link for the manifesto where they clearly mentioned that it's like high time that we have one uniform law for personal matters as well, and accordingly that should be introduced with regard to it. Right, then objectives of this Article 44 DPSP, it was mainly addressed so that there is discrimination against vulnerable groups can be reduced. There is one law which is applied to all, and same sort of rights or privileges are being enjoyed by all the people. It was incorporated in Constitution as an aspect that would fulfill. So whenever basically the state is able or state thinks it fit, they can accordingly introduce it like that it was basically introduced. Now, origin of Uniform Civil Code. While discussing property law, we saw, right, that when Britishers came, they took active part in legal matters in India. But they said that let these personal matters be decided how they were already decided, like let the religion of the person decide what laws will be applicable, but they only tried to introduce laws with regard to these other criminal matters and stuff, right? Those matters they had introduced legislations, but personal matters they left it to the like religion of the person basically. So accordingly, this Uniform Civil Code was lacking from that time until now we don't have it. But with regard to Goa, there a lot of matters are for lot of matters, right? They have like legislation based on that. It is decided irrespective of religion of the person. Okay, there might be few things wherein all personal laws are involved, but otherwise they have like a uniform civil code. Okay, as compared to rest of India, they are having provisions with regard to it. So origin, it just started because British government did not interfere in terms of this family matters, and they allowed that whatever personal laws are there, that only can be applied. So this thing still is continuing and we do not have like a uniform code except for Goa. So why uniform civil code is needed? Because everyone will be getting same kind of rights, right? Based on religion of the person, matter will be not decided. Like in case of Muslims, they can marry up to 4 wives, right? In case of Hindus also, initially it was allowed, right? That they can have 2-3 wives, but now it is not allowed. So once uniform civil code is introduced, it will have like same sort of laws for all. Right, like until few years we were having this triple talaq in case of Muslims, right? So those things also will be removed completely if uniform civil code is being introduced. Similarly, there was this case also, Muhammad Ahmed Khan versus Shaira Banu Begum, which is like a very popular case under Muslim law, which relates to this 125 I said, right? Section 125 of CRPC. So it is related to that section itself, right? So there was this Muslim woman, Shaira Banu, and she was married to one advocate in Indore, Madhya Pradesh. Okay, she was married to this person for 14 years and they had 5 children from that marriage. After 14 years, he got married to another woman because it is allowed in Muslim law to have up to 4 wives, right? So both, he was having like both the wives. But after many years, right, when she was about 62 years old, he divorced her, all right? And she was not having any sort of, like resources herself. So her husband said that I will be giving you like 200 rupees maintenance to look after yourself and also the children. So I will be giving you 200 rupees maintenance every single year. But after a certain duration, he stopped giving that maintenance also. Okay, and then she filed the case in the court saying that she should be getting maintenance of 500 rupees because she need to take care of herself, her children and stuff. So she should be getting 500 rupees maintenance under that section 125 of CRPC. All right, then she approached the lower court. They said that, okay, fine, you are, like they told the husband that you give her 25 rupees as maintenance. She filed an appeal in the High Court. High Court said that, okay, fine, you give some 179 rupees to her. But then she finally approached Supreme Court and Supreme Court said that this section 125, which we have, right, from CRPC, that provision is not, like with respect to any specific relation, it is open for all. So under section 125, it was ordered that her husband should be giving her maintenance based on that section, right? Accordingly, that section was made applicable. And then there were times where other people also filed cases to ask for maintenance under that section or under that provision. But now we have like one legislation based on which these matters are being decided. Okay, Muslim Women Protection of Rights on Divorce Act 1986. So we again have this, like this personal law which will decide the matter with regard to maintenance that a Muslim woman will be getting after her divorce, right? So under Article 125, she got her maintenance, but now again we have this legislation which will say what all, like rights or what all maintenance and other stuff this Muslim women will be getting after divorce. Okay, then there is another case, Shaira Banu case of 2017. And in this case also, right, after I think some 12 years or something of the marriage, her husband divorced her, all right? And like there was this dowry thing involved, okay? The family was basically demanding that you give us some money plus a car also you give. Then her father was not able to afford all that stuff. And there was this domestic violence and everything. And finally, the husband, right, he sent basically like by post, he sent a letter saying talak, talak, talak. Okay, so it basically is like if you pronounce talak 3 times, the marriage gets, like the marriage will end. So when it happened, right, she filed a case saying that this sort of a practice is not valid Because otherwise in other laws, right, if you want to get a divorce, you need to apply, like there are some grounds based on which you can apply. You can simply not go to court and say that I want divorce, right? You need to prove those grounds, that based on these grounds I want a divorce, or that both the parties have decided, like mutually we decided to get separated, so accordingly you can ask for divorce. But it's not like simply one day you say divorce, 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 and it's done. But that was applicable in terms of Muslims. So she filed a case saying that this talaq-e-biddat thing is not valid and it should be like considered unconstitutional, basically, right? She said that. Then there is another thing called as nikah halal. Have you heard that? Might be in movies and all, you have seen this thing, nikah halal. Have you heard of it somewhere?
No, madam.
In movies, they usually show this thing. Okay, what it basically is, right? In case of any other, take for example, there are like two persons, okay, husband and wife, they got married, they decided to get divorced, all right, they divorced each other. After that, they again decided that no, we again want to, like be with each other, right? We again want to get married. In that case, for other religions, right, you can again get married, there is no issue in that. But in case of Muslims, what happens, right? Once these like two persons, right, they are divorced, they cannot again get married unless and until this wife got married to someone else, got a divorce from there, and then only she will be basically entitled. Okay, so this is very common thing that is shown in some these things, okay, movies and all, they would show also. So what happens, right, basically wife, it's like violating her rights, right? She just wanted to get married to her husband. There is like unnecessarily this step involved, right, wherein you get married to someone else and then you get a divorce from it, and then you again get married to this person. And in this in between, what happens, right, sometimes this person with whom she would get married might be some cousin, some relative, or someone. This person will say that, okay, fine, now I'm not giving you divorce. In such a case, what happens is this wife, she will be, like in middle of somewhere. She cannot get divorced also, she cannot get married to this person also. So those issues are there. So this case, right, Shaira Banu case, she basically challenged all this stuff, that talaq-e-biddat, triple talaq is like unconstitutional, it should be completely banned. Also, this nikah halal is a very bad thing, that also should be stopped. And also that Muslim men are allowed to have up to 4 wives, that thing is also like not right, that also thing should be stopped. So accordingly, she filed a case. And during this, when the case was being decided, there were different opinions of judges and stuff. They said that, okay, fine, we are for a temporary period putting a ban on triple talaq, let the like parliament decide and stuff. And finally it was considered as illegal, right? If someone pronounces triple talaq now, that person will be given punishment. It's like illegal criminal offense. Okay, so this thing is being done. So like that, it's like so many cases wherein people came forward, fought for it. Those things would not have taken place if we had a uniform law which applied to all the people, right? They would have been able to enjoy same rights and privileges, basically. But what is the problem in introducing this uniform civil code? It is basically like we have so many different religions, right? And all these religions are having their own different laws, right? So in case uniform civil code is being introduced also, which law, which like provisions from which religion will be like taken, and which one will be removed, basically, right? So there is that confusion also, that which things to be taken, which things to be omitted. Because of all those things, right, it is still like we are not able to introduce a civil code, right, which is uniformly applicable to everyone irrespective of their religion. So it is being said that we only want to introduce a law which provides same kind of rights and all. Okay, whatever ceremonies are, whatever other things are, let those things be as it is. Like if like two Hindus want to get married, they can get married based on their own ceremonies, their own functions. No harm in it. But when the matter comes with regard to their divorce, maintenance, child custody, and other stuff, in such cases, we should be having like a uniform law which applies to them. Same will happen for Muslims. They want to do nikah, let them do it. But when the matter comes before court for decision, at that time, same law should be applied. Right? So that basically is the thing with regard to uniform civil code. So we are yet to see some progress regarding it. And this is like a conclusion thing that you can write. Okay, that the uniform civil code, it must try to balance in between protection of fundamental rights and religious rights of individual, because we are being given this religious freedoms also, right? Under constitution also, it's a fundamental right to protect these religious sentiments and stuff. So it has to be like properly balanced in between both the two things, so that our fundamental right to practice, profess, propagate any religion is also not being violated. And at the same time, people are not being discriminated in terms of what right they enjoy based on like religion of the person also, right? So this is with regard to Uniform Civil Code, Article 44 of the Constitution. Okay. So is this part clear?
Yes, madam.
Okay.